if the court held that the corporate entity is a natural person somehow, that would make every foreclosure involving a home loan.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
Today on The Weekly Friedman, we're taking a closer look at how New York's statutory definition of a home loan affects key foreclosure notice requirements. Specifically, we'll break down a recent trial court decision that reinforces a critical boundary in the application of the 90-day pre-foreclosure notice under RPAPL 1304. In Wilmington v. 294 Combs Avenue LLC, the court held that RPAPL 1304 protections do not apply when the borrower is a corporate entity, even if a guarantor who lives in the property tries to argue otherwise. Joining me today to break it all down is our senior appellate counsel, Vargas. We'll walk through the court's reasoning, what this ruling means for lenders, and why borrower identity can shape your entire litigation strategy. All right, Steve, thanks for joining me today.
Of course.
Always excited to have you on here. So let's just walk through the basic facts here. So are we saying that this is a corporate entity borrower, right, an LLC?
It is.
And there's a guarantor that signed the loan docs that
Yes,
then made an argument that because they're a natural person, they should get a 90-day notice?
That's correct. The action was commenced against borrower 294 Combs Avenue LLC. That's the name of the borrower on the loan documents, as well as the guarantor, a natural person. And the natural person obviously signed as sole member of the LLC the note, the mortgage, and then in her individual capacity signed a guarantee. So she promised to repay the money, but also mortgage the premises by virtue of her role as the managing member or president of the LLC. Property goes into foreclosure, and the bank did not send one of the RPAPL 1304 90-day notices on the basis that the borrower was not a natural person, which is one of the statutory requirements for eligibility to receive a 90-day notice.
What's interesting here is if the borrower was successful, then wouldn't the home loan definition just go away?
Potentially, and that I think was the court's reasoning in part as to why the court agreed with the plaintiff's argument. The legislature defined a home loan as, among other things, a loan in which the borrower is a natural person. There are several other subsections, but it's relevant here. RPAPL 1304, subsection 6, and then subsection A, another subsection 1, subsection Roman numeral lower 1. The statute's very technical. So 4 subsections beneath the main section itself. One of the elements in order to receive a 90-day notice is for the borrower to be a natural person. Case law has interpreted what borrower means. So in the seminal case, it goes back to 2011, Aurora Loan Services versus Weisblum, and the second department in that case said, and all the other appellate courts ultimately agreed, that a borrower is anybody whose name appears as defined by borrower in a mortgage and note or a modification agreement. So on usually page 1 of the mortgage, page 1 of the note, it says borrower in bold font, and then it lists 1, 2, 3 individuals or corporate entities who's the borrower. In this case, 294 Combs Avenue LLC is the only entity identified as borrower. The only identification for the natural person was as a guarantor or as a president/member of that LLC. So clearly the parties did not contemplate that this person would be defined as borrower under the loan documents. And based on 14 years of precedent, the LLC is the only, quote, borrower. Inherently, a corporation would have to have documents executed through a natural person anyway. So to your point, if the court held that the corporate entity is a natural person somehow, or the fact that the borrower is someone who signed the loan documents, that would make every foreclosure involving a home loan.
So was her argument that she's a natural person who signed as a borrower, or is her argument she's a guarantor?
This individual is claiming that she is a borrower because she occupies the mortgage premises. She's a natural person who occupies the mortgage premises. So one of the other subsections of RPAPL 13046 in that statutory definition of a home loan is that the borrower must occupy or intend to occupy the mortgage premises as his or her principal dwelling. And she's saying, I am a natural person and I occupy the premises as a principal dwelling. She was served at the mortgage premises. There's no dispute that she occupied the premises. The record reveals that. The issue solely turned on whether the fact that she may meet some of the other subsection elements is enough to overcome the fact that she did not sign the note or the mortgage in her individual name. They're only signed identifying borrower as 294 Combs Avenue LLC. That was critical here. The court just said, the legislature said borrower must be a natural person. Face of the loan documents shows she's not, and that controls. To your point, in the event that the trial court ruled otherwise, you'd have potentially persuasive authority that in the LLC scenario, where the borrower who signs on behalf of an LLC lives at the property, all of a sudden these statutory protections apply. Not all instances does the managing member of an LLC reside at the mortgage premises in these commercial foreclosure situations or business purpose foreclosures, but sometimes the person will reside at the property. And that would then expand the 90-day notice protections to people beyond what the legislator contemplated that the protections would be given to.
Not to keep honing in on this one point. Her argument was, I live in the property, I am a natural person, and I'm a guarantor, and I signed the loan docs on behalf of the company.
She didn't claim that her status as guarantor made her a borrower under the loan documents. She claimed instead that she signed documents on behalf of the LLC. So the mortgage and the note used the LLC's name as borrower and then signed by her as managing member / president of the company. And she's saying, well, I did sign the loan documents. My signature is on them, but the court said, yes, it is, but as a member of the corporate entity, not in your individual capacity. And in essence, that's what the guarantor exists for. Her personal liability was established through the production of the guarantee rather than production of the note, which she's not in a vacuum liable under.
Okay. I mean, look, fortunately, this worked out the right way. I think this would have been a mess if it didn't.
Absolutely.
Like, this would have been another one of these things where we have 9 podcasts on it because it would uproot how business purpose lending functions.
Correct. Even though she signed a business purpose affidavit, she was making these claims. And interestingly, this is Richmond County trial court. So it wouldn't have been binding precedent, but it would have been a problematic trial court decision that the defense bar would have latched onto and cited repeatedly. And like you said, even if it was an outlier decision that was adopted by a handful of courts, it still becomes a problem, requires appellate intervention.
You brought up an interesting point there, though, that I was actually going to raise. So she signed a business use affidavit or a business purpose affidavit?
Correct. She signed a certification that the loan was not being taken out for personal purposes. Even though she ended up ultimately residing at the premises, she did sign a certification that the loan was not being taken out for personal or household purposes. Rather, it was being taken out for some sort of business purpose. And she was bound by that. Even though she ultimately decided to live there instead of, let's say, renting it out, it didn't matter. The origination of the loan was for her to take it out as a non-primary household loan. But then later on, for whatever reason, she ended up occupying it and then tried to use the fact that she occupied the premises to defend the foreclosure. Now, the foreclosure, if it had been dismissed improperly by the court, obviously the appellate intervention could have been sought. The plaintiff could have restarted by mailing the 90-day notices, but that's not the point. To your point, the bigger issue is all of a sudden you'd have a decision expanding 90-day notice protections to LLCs, and given the increasing volume of commercial corporate foreclosures, in the post-COVID foreclosure landscape, it could have caused havoc in pending cases and imposed new burdens on future cases. And then interestingly, if you try to expand the scope, if the home loan definition were expanded, you wonder how it would affect arguments under Banking Law 6M, Banking Law 6L, other subsections of the RPAPL, if defendants would try to say, well, now all of a sudden these statutory requirements are now expanded. And that's certainly a possibility. It would have been a major problem.
All right, Steve, thank you.
Of course.
Thanks for joining Stephen Vargas and I on the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.